There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello, America. Hello, cyberspace. Hello, citizens and patriots. This is Paul Engel. We are at the Constitution Study, and we are here to read and to study the Constitution, to teach the rising generation to be free, to return the Constitution to its rightful owners, we, the people of the United States. We are here to read and study so that we may know what our rights are and be better prepared to defend and assert them. I'm glad you could join me today. I hope you're enjoying the series. I hope you're enjoying your 2019. It's been interesting so far. If you want to find out more, head over to the website constitutionstudy.com. That's where you'll find out everything regarding the Constitution Study, whether it's local studies you can join or articles and news that is coming out. It's been interesting. We even have a live stream now. So starting in 2019, I have a monthly live broadcast. You're welcome to join. I do it through Facebook. You can find out more at the website. You can also ask questions. I love questions. Questions drive a lot of what we're doing now. The book has been drafted. It's currently being edited, so I'm spending a lot more time answering people's questions. And that's kind of where today's idea comes from. The topic I want to cover today comes from, well, it actually comes from a lawsuit, a case that was heard before the Supreme Court. But I'm focusing on it because I've seen a lot of discussion on the blogs, on the posts, on Facebook around this idea that we're going to talk about. And I wanted to get out there a real constitutional understanding. See, now, if you've paid attention to some of the news, if you're like me, if you follow a bit with what's going on at the Supreme Court, you may have heard about a case called Timms v. Indiana. Mr. Timms is claiming that the forfeiture of his vehicle as part of a drug sale case constituted an excessive fine prohibited by the Eighth Amendment. What makes this interesting, at least for me from a constitutional point, is this argument that the Eighth Amendment is, quote unquote, incorporated against the states under the 14th Amendment. See, this really got me thinking about what's known as the Incorporation Doctrine, how it's blatantly unconstitutional, how it's a 19th century fiction that has so distorted the legal minds that it seems even discussions I'm having today are distorted. They're twisted by this general idea that parts of the Constitution apply to the states and parts don't. So what is this Incorporation Doctrine? Well, if you haven't heard of it, let me give you the Wex Legal Dictionary definition of it. Again, from the Wex Legal Dictionary, quote, "The Incorporation Doctrine is a constitutional doctrine through which the first 10 amendments of the United States Constitution, known as the Bill of Rights, are made applicable to the states through the Due Process Clause of the 14th Amendment. Prior to the doctrine and the 14th Amendment's existence, the Bill of Rights applied only to the federal government and to federal court cases. States and state courts could choose to adopt similar laws, but were under no obligation to do so." So the Selective Incorporation Doctrine, or just better known simply as the Incorporation Doctrine, is the belief that the Bill of Rights does not apply to the states, or at least they didn't until the 14th Amendment, which began incorporating certain parts of these 10 cherished amendments against the states. This legal brief about the Constitution started in 1833 with a case called Barron v. Baltimore. See, this took place, obviously, in the city of Baltimore. And what they had done is they'd started over the years several city improvements. And these improvements affected water flow. They redirected streams. And now these streams and their runoff was dumping sand and earth near a wharf that was owned by a company called Craig and Barron, basically making it unusable. An heir of Mr. Barron sued the city looking for compensation for the loss of use of their wharf. You see, the plaintiff claimed that their right to enjoy their property without being interfered with was taken away by the city of Baltimore for public use, and the Fifth Amendment required there be just compensation. The question before the Supreme Court was, do the provisions of the Fifth Amendment apply to the states or only to the central government? Now, what's interesting is the county court and I believe the state court of Maryland both said, yes, the Fifth Amendment applies to the states. It was the Court of Appeals and eventually the Supreme Court that looked at this differently. Now, the opinion of the Supreme Court was delivered by Chief Justice Marshall, and he said, quote, "The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. If these propositions be correct, the Fifth Amendment must be understood as restraining the power of the general government, not as applicable to the states." Now let's stop and think about that for a second. The Constitution is by definition a compact between the states. It is a contract. It is an agreement between the states. And in this agreement, the states agree to delegate certain powers to a new central government, or general government as it's referred to at this time. Now, if that's the case, wouldn't the contract have to be in effect against the states? It wouldn't have to have an restraining power on the states? Now, there is some logic behind what Justice Marshall is talking about. So he goes on to describe how there are some clauses in the Constitution that specifically say what the states can and cannot do, while others do not. They're general statements. Now, his point was that if there doesn't specifically say the states shall do or shall not do, then it's assumed to apply only to the general government. Quote, "If the original Constitution in the 9th and 10th sections of the first article draws this plain and marked line of discrimination between the limitations it imposes on the powers of the general government and on those of the state, if in every inhibition intended to act on state power, words are employed which directly express that intent, some strong reason must be assigned for departing from this safe and judicious course in framing the amendments before that departure can be assumed. We search in vain for that reason." So he's basically saying is, unless the Constitution says the state can do this, the state can't do that, unless it specifically says the states, then we have to assume that the rest of it was only meant to apply to the general government. It is possible. I agree that can be read into it. Right? In other words, Articles 1, 2, and 3 create the general government, right? The legislative, executive, and judicial branches. So there is a lot of focus on what the general government can and cannot do. And the idea which he promulgates but doesn't actually give evidence for is that, well, since there are places where the state specifically is mentioned, then everything else must apply only to the general government. He gives no form for it, only his assumption that the people formed the government, which we did through the states, right? Because it's the states that signed and ratified. That therefore, you have this strict division. And in general, I would tend to agree with Chief Justice Marshall that, without specific language on the application of the Constitution, I could see the logic between it assumed to apply only to the general government. There's just one tiny little itsy-bitsy little problem. See, although the justices, quote, searched in vain for that reason, it was literally hiding right under their noses in Article 6, Clause 2. It's referred to as the Supremacy Clause, and it states, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding." See, if there really is an incorporation doctrine, that's it right there. The Supremacy Clause, Article 6, Clause 2, clearly states the Constitution is the supreme law of the land, and that judges in every state are bound to it, regardless of the laws or constitution of their state. That means the Baltimore County judge was bound to the Fifth Amendment as he is to any other part of the Constitution. In fact, when there's a conflict between the state constitution and the U.S. Constitution, the latter must win. It is supreme. Now, I've done other work on the Supremacy Clause because it's really abused quite frequently. It doesn't mean that everything the federal government does is supreme. Laws made pursuant to the Constitution, meaning laws that fit within the power and scope delegated to the general government. But what we have here is a clear statement that what the Constitution says must be applied not only to the general government, but to the states as well, since the judges are bound to it. In fact, so why, I wonder, couldn't the justices of the Supreme Court find this little tidbit? Had they not read that? Had they forgotten it? Had their assistants and others not been able to find this? Was the common idea that this one clause of the Constitution just kind of been lost? I don't know. I'm not going to impute ideas when I don't have the facts. What I do know is that regardless of the merits of the cases brought both by Mr. Barron in 1832 and Mr. Timms in, I think it was 2016, and argued in 2018, this idea that only parts of the Bill of Rights apply to the states comes solely from the minds of those in the judicial branch. It's not really a surprise. I mean, why would a branch of the federal government not want to decide where and when certain parts of the Constitution apply to the states, or apply to them for that matter? And since almost nobody, including lawyers, judges, politicians, and Americans, even bother to read the Constitution, this fairy tale has lived on for almost 200 years. This is why I stress that we need everyone, from lawyers to judges, politicians to bureaucrats, teachers to everyday citizens. We need to read the Constitution for themselves. We need to read it. This experiment of leaving the interpretation of the Constitution to some high priesthood of judges, it's proven to be an utter failure. Our ignorance of the basic concept of the Constitution has led to some very interesting discussions and debates I've been working on through Facebook. You can see them if you look at what I post and where I'm referenced. This idea that either the federal government is in charge of all, or the states have no allegiance to the Constitution. I really find the idea that part of the Constitution applies and part doesn't to be quite ingenious or just quite weird. I'm not entirely sure. It's past time that we not only restore the Constitution to its rightful owners, us, we the people of the United States, but restore constitutional liberty to them as well. We need to know it. See, only when we know our rights, only when we know the Constitution, will we have a real opportunity to protect our rights and liberties, to push back on judges who say, yeah, no, the Constitution doesn't say that, when plainly it does. When the Constitution says shall not infringe, it means shall not infringe. Whether that be your right to free exercise of your religion, speech, carry a weapon, to be safe from unreasonable search and seizure, to have a jury trial. If we let other people decide what the Constitution does and does not say, and where not it will not apply, then the Constitution literally means next to nothing. And that's really what's driven me here to this desire to educate, to help people read for themselves. I love working with people, but I really don't want you to just take what I'm saying. I want you to read and study it for yourself. I want you to make it part of who you are. There's a reason why John Jay made the quote that I use so often in this Constitution study. Yes, he was another Chief Justice. He was the first Chief Justice of the Supreme Court of the United States. And he was the one who said, every member of the state ought diligently to read and to study the Constitution of his country and to teach the rising generation to be free. He didn't say listen to some commentator or some teacher tell you what it says. Read it for yourself. Study it for yourself. And then teach the next generation what it says it will as well. Teach them to be free. We haven't done that in generations. We are reaping the benefit of that ignorance. And unfortunately, it's costing us dearly. Mr. J and the rest of that quote said, by knowing their rights, they will sooner perceive when they are violated and be the better prepared to defend and assert them. We live in an age where most people don't know what their rights are, or they think their rights are something that really can't be rights at all. They don't recognize when their rights are being violated. I make that statement by seeing how many people are asking the federal government to violate their rights. Makes my head want to explode, but I see it. I see it almost every day. And when we do see our rights being violated, we seem ill-prepared and unwilling to defend them, to assert them, to tell our the people we elect to represent us, no, you swore an oath to uphold the Constitution. That includes protecting our rights. Do that or get another job. And this is just another example. We now have a court that is part of the federal government that's going to tell the federal government and the states who created the federal government what they can and cannot do based on an almost 200-year-old interpretation of the law that has absolutely zero, that's right, zero basis in fact, zero basis in the law. But that's what we've become. We've become a nation not of laws, not of self-governed, but of serfs that wait for our masters in the Supreme Court to determine what the laws will and will not do, what they do and do not say, and what we will and will not be allowed to do. And this is just another example. So I hope you found that interesting. Look into the Incorporation Doctrine. Read Barron. You can find it online. I'll put some links in the show notes here. Read for yourself. Go and find what it is I'm talking about. Read it, learn it, and then use it to educate others. I'm seeing a lot more interest lately in the Constitution and what it says. I'm hoping that this nascent reality of the danger our rights are in grows and blossoms into a flower of liberty for our nation. That will happen when we put in a little bit of time, a little bit of effort, when we learn what our rights are, when we learn how to defend and assert them, and most of all, when we learn how to protect not only our rights, but the rights of others. I hope you enjoy this. I hope you'll head over to the website, constitutionstudy.com, sign up for the mailing list, keep track of what we're doing here. Most of all, I hope I made you think, and I hope to see you again the next time on the Constitution Study. Good day.
Every day